on a few things. First thing, on cause number 5A0421962, you're charged with 1 count of failure to transfer title within 45 days, 1 count of driving with license suspended in the 3rd degree, 1 count of a trip permit violation, and then there's also a trailing infraction of operating a motor vehicle without insurance. Anytime anybody is charged with a crime, they have a number of rights. You have the right to be represented by an attorney. If you can't afford an attorney, I can appoint an attorney to represent you at little or no cost. Did you hear those rights?
Yes.
Do you have any questions about them?
No.
Okay. As I said at the outset there, you have the right to be have an attorney appointed to represent you. Do you wish to have court-appointed counsel? Are you going to hire an attorney, or you also have the right to represent yourself if you can do that? Do you have a?
I'm not sure at this point I need to hire counsel.
I'm sorry?
I'm not sure at this point I need an attorney.
Okay. And then do you want to, Mr. Shashevsky, he's there from the Office of Public Defense. I can appoint his office to represent you. It may or may not be him. Is that something you're interested in, or are you going to represent yourself for a period of time? You can always readdress this issue at some point in the future. I just need to know where you're headed today.
Well, as I said, I'm not sure at this point that I need an attorney.
Okay. Well, you have the right to one. Whether we can debate whether you actually need one. It's been my experience that when people are charged with a crime, they generally benefit from having one. But if at this point, based on what you said, I won't appoint an attorney at this point. But if you wish to readdress that at some point, you can do that. In terms about whether you need one, I think it's a good idea to have one, but you were going to say something?
Yes, it's been my experience that attorneys in the state of Washington advise their clients to perjure themselves in court when they're charged with domestic violence. They tell
Okay, so hang on just a second. I'm going to stop you there for a second. This case does not involve domestic violence. This is a simple, just stop for a minute. Let me finish, please. And so, and I can't speak to your experience outside of this court. I don't want to get previous experiences you have with an attorney or not get in the way of what we're doing here now. It's just a simple yes or no question. You whether want an attorney appointed to represent you or not. And if the answer to that's no, then we're going to proceed. And if the answer to that's yes, then I'll appoint your public defense, and then we'll go from there. Or you can hire someone. I tend to doubt that every attorney in the entire state, if any, do what you say, but you can hire an attorney of your own choice if you wish to do that. Well, I'm sure you could find someone. So what do you get? But what I need to know right now, I don't want to get into a philosophical discussion about what attorneys do or don't do in outside of this particular case. I just need to know whether or not you're interested in having an attorney appointed to represent you or not. And that's a yes. I'm asking you a yes or no question.
Well, let's just say that because of the conduct I've witnessed by attorneys, that I boycott.
Okay, so I'm going to take that as a no, and so I won't appoint an attorney to represent you at this time. But at the same time, again, I'll tell you again, and you're probably going to get told a few times over the course of this case. You can readdress this issue if you wish to do that. Who's handling this for the state? Mr. Clark, is that you?
I am.
I'm going to swear you in. Could you raise your right hand, please?
Yes.
Do you swear and affirm the information testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
You can put your hand down. So what's going to happen here now is this is an arraignment. This is the initial court hearing where you advised of your rights. Pleas of either guilty or not guilty are entered. If a probable cause is established, then I can set conditions of release. I swore in the prosecutor because I'll take his sworn testimony, which can include hearsay and reports from others, to establish probable cause. If I'm satisfied that probable cause exists for the charge going forward, the charge will go forward. We'll set conditions of release. We'll set a court date. I'll give you a court date. And then that'll probably conclude the hearing here for today. So Mr. You're going to say something?
Yes, I'm confused because he can be sworn in under penalty of perjury, but he's not a witness to anything.
He's not.
So,
but what he is for the purpose of setting conditions of release, and the case is not being tried right now. And so he's not a witness, but he's the representative from the prosecuting attorney's office. He's an officer of the court. This is more of an offer of proof to show what sort of evidence would be presented if this were to proceed to trial. And again, just, nothing's being proven here today. It's just, I want to know, and when judges do, when they're setting conditions of release, if probable cause exists, if an offer of proof could be made that probable cause exists for the charge going forward. And that's what I'm going to hear from him today. And so then when he's going to say that, that's, it's not going to be tried in front of me. Ultimately, if this case might eventually be tried in front of a jury, not me, but I'm just asking him to do this simply for the purpose of, again, whether I can be satisfied that probable cause exists for the charge going forward and for setting conditions of release and having the case move forward. So, Mr. Clark, go ahead.
Yes, Your Honor, on April 10th, 2025 at about 9 p.m. The officer stopped the defendant on Old Highway 99 for expired registration. At that time, the officer noted to have seen a Washington trip permit in the window that was dated November 21st, 2024. The defendant was ID'd via his Washington driver's license. A records check advised the defendant was suspended / revoked in the 3rd degree. And at that time, he spoke with the defendant, who stated that he had bought his car, he had bought it for his son, bought that car for his son and never transferred it to him, as he lived in Minneapolis. And that is all, those are the facts, Your Honor.
Okay, and so you're seeking probable cause for the trip permit and the failure to transfer title. I see the DWLS in the 3rd and the trip permit
Yes, Your Honor,
And
all
then-
3 charges.
and the failure to transfer title.
Yes, Your Honor.
So, Mr. Blatt, I will find that probable cause exists for the charge going forward. Doesn't mean the state's proved it beyond a reasonable doubt. They'll still have to do that at trial. A plea of not guilty will be entered on your behalf.
Objection.
Okay.
There's no plea of not guilty on the record. I've not entered the plea.
No, you haven't. I have entered one on your behalf, and you can, and you've, by your objection, you've preserved that for appeal if you wish to do that. And a not guilty plea preserves all your rights to trial, all the rights that I laid out in that recitation I gave you at the beginning. But a plea of not guilty will be entered in your behalf. I'm doing that. Your objection, I've heard
I
you.
withdraw the plea of not guilty. It is stricken from the record. Please don't give me the bum's rush. Let's do due process here instead of streamlining the process. I have some objections to the initiation of the complaint because I haven't been served a criminal complaint. The court rules require it. 2.1 subsection C requires a criminal complaint be filed.
In courts of limited jurisdiction, in district court, complaints you can also be charged by citation by the charging officer, which has taken place in this case. That's how it got charged, with a citation. If you want a copy of that citation, we can certainly give it to you. You have it.
Yes.
So you can't, so again, I'm not quite done yet. And so, again, I'm satisfied that resolves that issue. If you have issue, and clearly you do, and I'm not trying to give you the bum's rush. I'm just trying to, I am trying to get through the hearing. If you have issues, if you want to object to, entering a plea, well, I can ask you, are you going to enter a plea at all? If you're not going to enter a plea, then again, I think that the law supports me entering a not guilty plea in your behalf, which does preserve all your rights, and and if you have issues, sometimes people attack these sorts of cases on constitutional grounds. They indicate that the licensing statutes are unconstitutional. You can do all that, but you've got to get all that stuff in writing and get it properly before the court in the form of a motion, but you can certainly do that. But the arraignment stage where we're at now is just as a preliminary stage, just it's kind of the kickoff, if you want to make a football analogy, and that's where we go from here.
Okay, I understand that, and I agree with that, but I require my public servants to obey the law because I've witnessed too much flouting of the law in Washington courts.
Okay.
So yes, I have been served a citation and notice, and that is sufficient to initiate a case. The problem is it's unsigned, and Court Rule 2.1 subsection B requires that it be signed. Now, before you came into the courtroom, prosecutor cited a statute saying that it can be electronically signed, but that conflicts with the court rules, and the court rules take precedent over statute because the court rules are promulgated by the state Supreme Court, whereas the statute's promulgated by some attorneys in the legislature.
I think there's Okay, well, like I say, you preserved that issue.
The issue
And
should be
you-
decided now.
What's that? No, you need to, again, you need to file appropriate motion and note it up for hearing. Anything else you wish to discuss?
Yes, I have some concerns about whether I'll get a fair trial. As I understand, this is supposed to be an adversarial process,
Mhm.
but I'm being accused by a police officer who works for the plaintiff. The prosecutor represents the plaintiff. The witness against me is the plaintiff. The jury that's supposed to sit here is selected because of their demonstrated loyalty to the plaintiff by applying for a driver's license when I'm charged with not having a driver's license. So they're inherently biased to begin with. You yourself have a flag behind you that represents the plaintiff. The public defender is licensed to make a living in the plaintiff's courtroom at the pleasure of the plaintiff. I've been educated by the plaintiff, so how can I get a fair trial in a courtroom where everyone represents the plaintiff?
Well, I'm not gonna do far of a deep dive into those things, other than to say, I don't agree with a lot of what you're saying in terms of who the plaintiff is and whether or not their ability to, whether or not your ability to have a fair trial will be tainted by his job and what he's required to do, or his job and what he's required to do. But, and again, I'm gonna go back to if you think that you, by that token, I guess if you were to take that to its logical extreme, no one could ever get a fair trial. I mean, people could do whatever they want, and I could say, like on that, yeah. Well, hear me out for a second. In terms of like, just as an example of, driving while intoxicated, if I think we would all agree that that's a bad idea. And so hang on just a second, and it is illegal to do that, but if no one could ever get a fair trial because the police are involved, then it would be, no one would ever, people could just do anything they want, drive, drunk all they want, and then they don't have to worry about it because a case would get thrown out, well, because they can't get a fair trial because the police pulled them over. And that doesn't seem to me like to be a great system. But again, I'm going to go back to where, if you have objections, if you have if you have a reason to believe that you can't get a fair trial, and you can convince a judge that that's the case, then you need to, again, put all that in writing, make a motion and go forward.
Okay, and I want to make sure the court understands, I'm not an anarchist, and I'm actually glad there's a process for keeping dangerous drivers off the road.
Mhm.
Problem is, the courts have connected family court with traffic court, and there should be no connection. The family court has power to suspend people's driver's license, and there is
So
no
hang on
due
just a
process in
second.
those courts.
Can I stop you for a second? And that is, this is a common misconception. The courts don't suspend license, right? The Department of Licensing does. The court gives information to the Department of Licensing to suspend the license. And so the legislature has decided that certain instances in family law, for example, not paying child support, and that's just one example that I can think of, that would suspend your license. So in the family court, if someone doesn't pay child support, they'll tell that to DOL, and then DOL was the one who suspends the license. So it's a misnomer, but hang on just a second. And so the family court's not doing that. The legislature decided that's a reason to suspend license, and then the family court's just providing the information to DOL. So if you want to be mad about someone about that, you could probably be mad about the legislature, about the legislature for passing that law. But it's not the court that's doing that. It's the legislature that created the law. The courts are providing the information. The Department of Licensing is doing what they're required to do as administrative agency and suspend the license. So how that happened, that all happened over in the state legislature. What we're here, but doesn't have anything to do with this, believe it or not. Now, here, you're just charged with, as I said, DWLS in the third, failure to transfer title, and a trip permit violation. There's also a no insurance ticket, which is about the most expensive thing. Pleas of not guilty have been entered, which you have objected to, and which you can preserve that for appeal. Conditions of your continued release are, don't have any criminal law violations, don't drive without license or insurance, and make all your court dates. And I'm going to give you a court date here in a couple of minutes.
Well, I object to those conditions on the basis that the court is presuming that I'm not allowed to travel in my car.
No, I'm not presuming anything. I'm setting reasonable conditions of release based on the charge, and that's pretty much it.
You're presuming I need a license to travel.
Well, you do need a license to drive on the highway, yes, absolutely.
Okay, well, I have a real quandary here because the court rules state that if I make an appearance,
Mhm.
that's construed as a waiver to any objections to the criminal complaint or citation and notice.
I think you can make any objection. You can raise an objection to your citation notice anytime you want. And if you can, again, note up the motion, and again, put it in writing, supported by law, case law or statute. And if you can convince a judge, which does happen from time to time, there are defective information, there are defective citations, and you can certainly, I've seen cases overturned on appeal because they've gone through trial and then they have an ineffective